Hello, I'm Jan Newharth, Chair and Chief Executive Officer of the Freedom Forum. Welcome to First Five Now, a Freedom Forum conversation series that explores topical issues and features current newsmakers who are using the five freedoms of the First Amendment to guide their work. Today, Jeff Kosseff, a cybersecurity law professor at the U.S. Naval Academy, talks about the history and future of Section 230 of the Communications Decency Act. Section 230 is considered one of the most consequential laws governing speech on the internet. And in recent months, there has been a renewed debate over the law and how it relates to free speech, as guaranteed by the First Amendment. This program is brought to you by the Freedom Forum, which fosters First Amendment freedoms for all. Our vision is an America where everyone knows, understands, values, and defends the freedoms of religion, speech, press, assembly, and petition. And now, please welcome our moderator, Lata Knott.
Thanks, Jan. I'm Lata Knott, a fellow for the First Amendment with the Freedom Forum, and welcome to First Five Now. Today, we're going to discuss Section 230 of the Communications Decency Act and why this law is garnering so much attention, and notably on Capitol Hill, as the law's future is debated on both sides of the aisle. Section 230 has come under fire from people on both the left and the right, but a lot of the conversation surrounding it seems to operate under a misunderstanding about what the law actually says and does. So we're really lucky to have lawyer and journalist Jeff Kosseff with us today to explain how Section 230 really works, how it relates to free speech, and what we should make of the controversy surrounding it. Jeff wrote the book on Section 230, The 26 Words That Created the Internet, which provides a history of Section 230 of the Communications Decency Act. He is an assistant professor of cybersecurity law in the United States Naval Academy's Cyber Science Department. In 2019, he was named an Andrew Carnegie Fellow by the Carnegie Corporation of New York to support his forthcoming book about the history of anonymous speech in the United States. And he's also the author of Cybersecurity Law, a textbook and treatise, and he's had numerous articles appear in the Iowa Law Review, Wake Forest Law Review, Computer Law and Security Review, and other law review articles and other law review and technology law journals. Thank you so much for being here, Jeff.
Thanks so much for having me.
So can we take on that initial premise of your book, The 26 Words That Changed the Internet? What is Section 230 and how did it create the internet as we know it?
So what Section 230 does is it says that a website, any online platform, is not legally responsible for the content that third parties, primarily users, create. The websites are responsible for content that they create, and there also are some exceptions, like for intellectual property law and federal criminal law. But in general, for something like defamation, if you were to go onto Facebook and post a defamatory post about me, I would be able to sue you, but what I couldn't do is sue Facebook for the post. Even if I complained to Facebook and they said, you know what, we want to leave it up. Even in that circumstance, the lawsuit would only be able to be against you and not against Facebook. And that's basically what Section 230 creates, is this liability regime where the user is the one who is ultimately responsible rather than the platform.
But if I say I wrote an op-ed for the New York Times defaming you, you could sue the New York Times though, right? What's the difference?
You could, and I mean, the Section 230 is premised on really this concept of internet exceptionalism, where the New York Times op-ed and letter to the editor page, for example, they might carry 10 or 15 different people's points of view per day. So there's an idea that there should be some liability for a publisher of that content. The New York Times website, on the other hand, where it would allow user comments, that would be covered by Section 230 because there's not such a limit. The idea for giving the internet these protections is really because the internet is fundamentally a different type of communications medium where people are able to really post their thoughts. I mean, I've written letters to the editor of the New York Times before in my life, and I've never been published in it. And I think a lot of people have that experience, but people do go online. They go on to Facebook, Twitter, Yelp, Wikipedia, all sorts of sites where they're able to get their thoughts, their ideas posted. And Section 230 is really fundamental to that, because if you were going to hold all of these platforms just as responsible as the authors, ultimately you probably would have fewer venues for user created speech, because there's just not much incentive to take on the liability for that content.
A lot of platforms might have been sued out of existence a long time ago, in other words.
Exactly.
Is that what Congress had in mind when they passed Section 230 or the Communications Decency Act?
Well, Congress actually had something, that was one of the things they had in mind. So it was to understand why they passed Section 230 in 1996. It's really helpful to understand what the rules were before Section 230. And that's basically, what does the common law and the First Amendment protect? And to understand that, that really goes back to cases in the pre internet world where distributors of other people's speech were sued. And that comes down to magazines and bookstores, those sorts of things, where they're companies that sell someone else's speech. And this goes back to obscenity cases in the 1950s and 60s, and it sort of got translated into defamation. But the general rule was that if you're the distributor of someone else's speech, you're liable only if you knew or had reason to know of the defamation. So we don't expect a magazine store to read every magazine cover to cover and make judgments about whether it's defamatory. However, if the magazine store gets a complaint about a defamatory magazine, then it might be on notice, and if it continues to sell it, then then it might face the same liability as the author. That sort of worked pretty well in the 1970s and 80s in a limited number of cases for bookstores and newsstands. The problem was when we got to these early internet services, Prodigy and CompuServe, um, and applying those rules to them when they were sued based on user content. So CompuServe did very little moderation. So when it was sued in the early 90s for defamation based on user content, the court said, you're just like a magazine stand, and you didn't know of the content, you had no reason to know, so we'll dismiss the case. Prodigy was a little different. They did a lot more moderation. They had fairly extensive user content policies because they wanted to be family friendly. So when they were sued for defamation, the judge said, you don't get that distributor protection. You're more like a publisher because you exercise editorial control. And this got a lot of attention in Congress because at the time they were amending the telecommunications laws for the first time in 60 years. And what they were really trying to do is figure out, how do we solve this prodigy problem, which is basically that platforms have a disincentive to moderate, because if they moderate, they face more potential liability for everything on their platform. So part of the reason for Section 230 was Congress recognizing, we want to get rid of this perverse incentive. The other reason that they passed 230, or they added it to the telecom overhaul, was because they recognized, the internet is this really burgeoning commercial enterprise that has so much potential. And what we don't want to do is regulate it out of existence or bog it down with all of these lawsuits. So that's how those were kind of the driving forces behind Section 230.
So Section 230 really has two things that it does, right? It protects the companies from being sued for what other people post on their sites, but it also allows them to moderate that content without losing that protection. Can you explain that second part?
Exactly. So there are two provisions in Section 230, and actually both of them help provide protection for moderation. The first are the 26 words that say, if you're an interactive computer service provider like a website, you are not treated as the publisher or speaker of information provided by another information content provider. So that's kind of the big shield of Section 230. But there's also a second section that says we're all that the platforms are not going to face liability for good faith efforts to block objectionable content. So it's basically saying you've got protection for what you might leave up, but you also have protection for taking down material. Now, the second part, Section 230 received barely any public attention when it was added. It's really kind of antiquated to see the coverage now. Most of the coverage of the Telecom Act was about like local telephone competition and stuff that perhaps does not matter as much anymore. But there's very little coverage of 230. But within the coverage of 230, um, there was probably more coverage of this protection for taking down content, for claims arising from removing content. But what we've seen is that has not been used, that it's been used in some cases, but it's not been nearly as important as the 26 words, in part because there's not a whole lot of liability, even without 230, that platforms could face solely from removing content or blocking users. And that's because, and I mean, this is something the courts have reiterated, the platforms have their own First Amendment protections to make these decisions about the policies that they set. So, I mean, most recently, a few years ago, Justice Kavanaugh wrote an opinion involving a cable access station, finding individuals don't have a First Amendment right to have their speech carried by a private party. The Ninth Circuit has applied that to YouTube, so individuals can't sort of bring a First Amendment lawsuit against a platform that blocks them. I mean, Twitter tomorrow could say, we don't like law professors named Jeff, so we're not going to allow them to tweet. And I wouldn't like that very much. But I also wouldn't have a First Amendment right to force Twitter to carry my speech.
So it's the platforms that have a First Amendment right to decide what content they want. It's not, we don't have the First Amendment right to get our content on their sites. But a lot of the debate around Section 230 does revolve around free speech. What do you think of that?
Well, so that's really started in the past few years. And what's really happened is really after the 2016 election, the platforms got a lot of criticism for the material that they kept up, disinformation and really harmful content. So they started to be more aggressive than they had been before in enforcing policies and setting policies on things like hate speech and disinformation. And they started taking down more content, demonetizing content, banning users. And that got a lot of people upset who were among the groups being banned. And what they started doing is bringing Section 230 into the debate, even though it's not really a Section 230 issue. To the best of my understanding, what the critics say is we give these platforms this massive protection under Section 230 that most types of businesses, frankly, just don't receive. And then they're going to come along and effectively silence us with their huge power, and that's not fair. And there is legitimate concern to that. There's when you focus especially on the big three or four platforms, there's real concern. These are companies that have market values that are greater than the auto industry, and they're unilaterally deciding whether to allow someone's speech to be heard, and that's concerning. Now, the problem is oftentimes their concerns really are not Section 230 concerns, and the bigger problem, the bigger barrier that they run into is the First Amendment. And there's also a procedural issue, which is assuming that platforms will have some sort of user content policies, they're going to upset some people. There's no way to have policies that say, these are the types of speech that we don't want to carry, without having people disagree with you. So that's kind of there's really a logistical issue that the platforms keep running into, that the critics keep running into, and I think part of it has been fueled by the fact that until recently, the platforms haven't been terribly transparent. At least the big platforms. They were fairly secretive and perhaps did not apply their policies equally to everyone. That's starting to change a little bit. I think it could change a lot more. And the other point is that when we focus on Section 230, the debate that you see in the popular press often focuses on Facebook and Twitter and YouTube and a few other big platforms, which obviously do benefit tremendously from Section 230. But they're not the only platforms that receive Section 230 protection. A small community news site that allows user comments, they uh, perhaps even rely on Section 230 more than a social media company with billions of dollars. The A consumer review site like Yelp, for example, really could not exist in its current form without Section 230 because Yelp, for example, takes the position that they'll remove certain types of content that violates policies like for privacy and things like that. But if a business says that consumer wasn't telling the truth when they said that I ripped them off, Yelp says, generally we're not going to get involved in these factual disputes. If you didn't have Section 230, Yelp would face a lot more pressure to take down that content because I don't want to speak for Yelp's legal department, but if I were their lawyer, I would say, there's no way that I could litigate all of these claims on the merits about whether a mechanic overcharged for service or things like that. So that's really what. So it's not. It definitely does enable the business models of Facebook and Twitter and so many other big platforms, but it also is so fundamental to any site that allows third-party content.
So if I had a blog and I had a comment section, would I get Section 230 protection?
Yeah, absolutely. You get Section 230 protection for the comment for the user comments. Now, if you would not get Section 230 for your blog post, and if you responded to a user comment, your response would not be covered by Section 230, but anything that the users post would.
That makes sense. All right. So I will take down my post slandering law professors named Jeff and focus on just letting people comment. Now, what's interesting about what you said is you're right. We mostly forget that that Section 230 applies to more than just YouTube and Facebook and the large companies. Although, I mean, obviously they control a lot of the public conversation. And when we see arguments, I mean, you mentioned that we've seen arguments like usually from the right that these companies are allowed to engage in political censorship. We also see arguments like from the other side of the political aisle that Section 230 allows companies to spread hate speech and misinformation, or allows that to spread on their platforms. What do you think of that?
Well, I think it depends on what the actual harmful content is. And I mean So I'll give a brief story. This must have been about 2 years ago, just as the Section 230 debate was heating up, and I got my first interview request from the New York Times, and I was so excited. I was like, "Wow, I'm going to be in the New York Times." And I spoke with the reporter for like an hour. They used one quote, but that's okay. I was in the New York Times, but the problem was the article. It was across the entire front page of the business section, and the headline was something along the lines of this hate speech is a huge problem on the internet. There was a picture of the 26 words in Section 230, and then underneath it, there was another big headline that said something along the lines of because this law protects it. Now, the problem, as the folks at the Freedom Forum know, is that it's actually the First Amendment that protects hate speech. And the New York Times had to run a correction saying it's actually the First Amendment and not Section 230 that protects hate speech in the United States. Now, obviously, that's in other countries, that's not the case. Their equivalent of the First Amendment does not protect hate speech. speech. You have countries like Germany that have anti-hate speech laws, but we couldn't have that in the United States under the way that the First Amendment is interpreted. So things like hate speech, even if you didn't have Section 230, you couldn't suddenly have an anti-hate speech law because I mean, unless you have a really radically different interpretation of the First Amendment or you amend the Constitution. And so there's a lot of problems on the internet that are not necessarily Section 230 problems. Now, there are a lot that are fostered, that are enabled by Section 230, and I think those are serious. I mean, I think defamation is one of them. I mean, there is very strong, if not complete, protection for platforms that host defamatory content. They don't have to take it down. Now, many do, but many don't. Some say we can't get involved in determining whether something's defamatory. So there are some harms that definitely are out there and that need to be addressed. And I mean, I think when you look at the two sides of the 230 debate, there's the folks who say there actually has to be less moderation. Those are the people we were talking about before who think that there's too much what they view as censorship. But then there are the people who say there's too much harmful content out there. I'm far more sympathetic with that side because there is a lot of harmful content out there. And I think we do need to look at how Section 230 plays into that and whether there are any changes that can preserve the open nature of the internet that so many people like, while also sort of helping to combat some of the more harmful content out there.
What kind of changes would you make to Section 230 if you had that power in your hands?
Well, so I think that we're not even at that stage yet because I think the problem is we sort of launched into this debate. And I mean, I speak with members of Congress and their staff, anyone who wants to talk about 230. And I feel like I'm living in two different worlds when I speak with them because some people say, you know, we want to stop these platforms from moderating. And others say we want them to do a lot more moderation. So I feel like we first have to come to an agreement on the problem before we figure out the solution. If the problem is there's too much harmful content out there, which is what I would tend to agree with, I think that we need to first get a much better grasp on what the realities are of moderation. I'm on a lot of Section 230 panels these days, and sometimes I'm on a panel with someone who seems to think there's some sort of magic technology you can just sort of plug into a platform and it gets rid of all the harmful content. And while AI and machine learning do help for some things, they're not a panacea, and there's a lot of things that you need human judgment for, which is why a lot of the big platforms have thousands and thousands of moderators. But even in those cases, sometimes it's hard to even make an informed judgment. So I think at a policy level, we don't even have a great grasp on what's possible. What I'd like to see, Congress recently passed a whole series of cybersecurity provisions, which is my other area of research, in the Defense Authorization Act, that was the result of the Cyber Solarium Commission, which was this very nonpartisan expert commission that did a lot of fact finding and came up with legislative recommendations. For like 2 years now, I've been saying that Congress needs to do the same thing with platforms because I feel like we're having kind of a very low fact debate. It's based on a lot of passion, a lot of really sincerely held beliefs, but not much factual basis as to how moderation works. And from there, we could get some proposals. Now, I mean, I have some tentative conclusions of things that should be fixes, and a lot of people disagree with me. For example, in the case of you posting something on Facebook about me, we talked about how I'd always be able to sue you. If I were to sue you and I were to win, so if I were to meet all the bars, the many hurdles for a defamation case and get a judgment that it was defamatory, one of the things that I'd probably seek is an order for the post to be removed. Now, many platforms already have a policy that if there's a court order finding something's illegal or defamatory, they'll take it down, but not all of them do. And there's a court ruling from the California Supreme Court that actually says that Section 230, in that sort of situation, Section 230 prevents a platform from being forced to remove that content. And I think that's wrong at a policy level. And there are legitimate reasons that people say. I mean, probably the most persuasive one is people are concerned that plaintiffs will forge court orders, and which has happened before. But to the extent that happens, I think that's a much bigger problem than just Section 230 and needs to be addressed. But we don't sort of, because people are finding ways to break the law, we don't decide we're just going to have a lawless society. I mean, if something is adjudicated to be illegal and not constitutionally protected, I mean, even I, a First Amendment lawyer, former journalist, think, okay, we should not have this law that Congress passed saying you don't need to take this down. I mean, in my experience, both with writing about Section 230 and my next work on anonymous speech, where there's a lot of anonymous trolling, I mean, plaintiffs in some of the most really heart wrenching cases are not seeking money. What they're seeking is to have the removal of material that's ruining their lives. And I think while we need to be really careful about when we can force removal, I mean, I realize that's a really big deal to say you have to take speech down. But at a certain point, we've got to say, okay, let's be reasonable here and recognize that we if there's been someone who's the victim of persistent harassment and someone who's posting on these sites that are known to not honor court orders, at that point, I think it's reasonable for Congress to step in and say this is not what we want.
So it sounds like you might be in favor of certain changes to the way that Section 230 operates as opposed to wanting to check it out as a whole. But what do you think is going to happen in terms of just with regards to the current political climate with Section 230? Because as you said, there's a bit of a fact-free debate going on, but passions are high on both sides.
And actually probably should have given this disclaimer at the beginning. I'm only speaking on my own behalf, not on behalf of the DoD or the Navy or the Naval Academy. And with that, I would say I'm fortunately not a political scientist. This has kind of been my exposure to politics, having dealing with a lot of different congressional offices on this issue. And I would love to say that I know what's going to happen. I feel like there's a good possibility nothing will happen because when I talk about how we haven't identified the problem yet, I think we're so far apart on what the problem is that it's hard to reconcile it. So maybe you'll get like just enough votes to get something through, but I'm just not seeing it now because you still have so many people who differ on whether the platform should be doing more or less moderation, much less figuring out whether we even have a solution that would get to that goal. But right now, we don't really know what the goal is. So until we have more consensus on that, I'm really not sure. I mean, the most likely would be Senator Schatz and Thune. It's a bipartisan proposal in the Senate, have something called the PACT Act, which goes slightly in a different direction than either of those two, and it has some procedural reforms, things like transparency, the ability for individuals to contact the companies, things like that. I would think that might be, again, I have no real insight into the political process, but I think that might be something that might be more likely to be more acceptable to both sides of the debate, rather than some of the other proposals, which either try to get the platforms to do less moderation or remove 230 protections for particular categories of user content.
So you mentioned that your next book is on anonymous speech, which I think sounds like a fascinating topic since You also mentioned that anonymous trolls can cause so much serious damage, but of course, anonymous speech is sort of baked into the DNA of this country. So I'd just love to hear more about what it's about.
Yeah, so this kind of was an outgrowth from my Section 230 book, which was, I mean, one big defense of Section 230 is, well, sure, you can't sue the platforms, but you can always sue the poster. And uh, I'm aware of a lot of cases where that's not necessarily accurate because the courts in the United States have provided strong but not absolute protections for anonymity. So there are some cases where you're not actually able to obtain the identity of the person who posted. You file a suit against John Doe, and then you subpoena the website for John Doe's IP address. If you get that, then you subpoena John Doe's ISP, and maybe you'll get a subscriber name that matches with the person who posted, but possibly John Doe has been using his or her neighbor's unsecured Wi-Fi, or John Doe is using Tor, so the IP address doesn't matter. And I was so fascinated by this, particularly by the fact that these subpoenas are not automatically granted, but subjected to a really tough level of scrutiny by the courts. And I was just curious why that is. So I started looking at tracing back the cases. And interestingly enough, they go back to the 1950s when, right after Brown versus Board of Education, when Alabama and Little Rock, Arkansas were trying to force the NAACP to disclose their membership lists. And they did so, like Alabama basically fined that local NAACP chapter for failing to register as a corporation. And rather than just allow it to pay the $5 fine, it brought a case against it in court for not paying the fine, not registering, and as part of the discovery in that case, requested all of its member lists. And the this was done by a state attorney general who was an open and proud segregationist, and there was very little dispute that this was being done to harass the NAACP. And it went to the Supreme Court, and they said, there's a First Amendment right to anonymity, and so it went to a few other cases 2 years later involving the distribution of anonymous pamphlets for a boycott against businesses that discriminate against racial minorities. And in that case, the Supreme Court traced this right to anonymity back to actually to England in the 18th century and the letters of Junius, and then the colonial American tradition of anonymous speech and political pamphlets, and the Federalist Papers being published pseudonymously. And so that really undergirds this qualified right to anonymity that the courts have found. And so I took that and I traced it to more modern debates involving the internet, including defamation cases where the plaintiff's trying to track down the anonymous poster. Interestingly, what I found was that this started in the late 90s, but it wasn't, there were some cases where plaintiffs were trying to track down people who were persistently harassing them, but the most common type of plaintiff by far were large companies. And the reason for this was in the late 90s, Yahoo started offering something called Yahoo Finance, which every publicly traded company had a bulletin board. And what was fascinating was that for the first time, the executives of these companies, who were only accustomed to being criticized possibly by business columnists and newspapers, they were being criticized constantly by their employees and shareholders, but usually their employees. And so these businesses were filing these lawsuits against basically every anonymous user on Yahoo that criticized them, and trying to subpoena their information, not to actually seek any money from them, but because they wanted to find out who they were and fire them. And so that was really the most common type of lawsuit, and the courts at first allowed this, and they gradually developed a fairly high standard. And so what I found is anonymity, this right to anonymity, really is intended to protect groups that otherwise would not have a voice. But you have to look at the other side of it and recognize there are cases of really persistent harassment where people use either legal or technical protections or logistical protections, like using a coffee shop IP internet connection to post things without any consequence to them that really can devastate people's lives. So my book makes a case for why we need anonymous speech, but also argues that the courts have given it enough leeway for these extraordinarily tough cases where you actually do need to be able to unmask the person.
That sounds fascinating, actually. There's just a lot to delve into there. And I really look forward to reading your book. When is it going to be out?
In February.
Thank you. And once again, thank you so much for being with us and for really walking us through Section 230, anonymous speech, and like sort of the both sides of the issue, and like how it's much more complicated than we often hear when we like read about Section 230 in the news. So very much appreciate you giving us this nuance.
Of course, thanks for having me.
And thank you for watching this episode of First Five Now. I'm Letha Knott.